So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about mandatory arbitrations. Mandatory arbitrations are a function of the private workforce. They're really interesting, and there's a possibility that they might be going away, at least in California. We want to talk about what that means, what arbitrations are, mandatory arbitrations are, and what the future of them holds, at least in California, maybe for the United States as a whole. So let's dive into it. So this title kind of poisons the well. Before we get going, the link is down below if you want to read more about it. But mandatory arbitrations are a contract that you sign before purchasing or beginning to work somewhere, or any number of things, including health insurance as well. And what it does is it's a requirement that you go through the company's court system rather than going through the legal judicial system. And I say companies court system, they're bound by actually going through an arbitration with a third party that is supposed to be neutral. And this can apply to a lot of things. Up until fairly recently, it was legal to do a arbitration, mandatory arbitration for sexual harassment cases and equal employment opportunity commission, which cases, which is just a little bit crazy. It seems to subvert the law in favor of sort of extrajudicial or otherwise sort of unfair proceedings, and it's a really interesting thing that many people are not aware of. This article is from Buchalter, and it says so. California has many assembly bills. There's tons of them. Here's Assembly Bill 51, which sought to ban mandatory arbitration, but that was overridden recently by a U.S. Supreme Court decision, among others. And it says California employers can require workers to sign arbitration agreements as a condition of employment. Uh, Following, there was a U.S. Supreme Court decision in Viking Cruises versus Mariana, which is where AB 5 preempted federal law, which is illegal. Uh, California Supreme Court in 2014 ruled that class action waivers were permissible under the Federal Arbitration Act. Um, what that means is that you can, hold people, or you can prevent class action lawsuits under the Federal Arbitration Act through a mandatory arbitration. And the interesting thing here is that it was recognized that AB 551 does not actually prohibit arbitration agreements. It just disfavors them by putting criminal penalties on employers who use them without an actual bargaining chip. So there's there's ways to, for instance, create bargaining chips where it's acceptable, but Assembly Bill 51 was preempted by the Federal Arbitration Act as a result, and the federal government always wins in these situations, of course, and that's where the power comes from with respect to the federal government. So the West Coast Ninth Circuit Court affirmed the injunction against the Assembly Bill 51 and ruled that the, AB 51 is preempted by the Federal Arbitration Act. As a result, it's not an acceptable. There's an injunction against it. The majority recognized that California enacted the act to protect employees from forced arbitration, but that the law only criminalizes contract formation. Now, I want to go back to this a little bit. In the prior to the 1930s, the minimum wage was considered to be unconstitutional because it interfered with the between the dealings between the employee and the employer. It violated First Amendment, freedom of association rights, and as a result, it was constantly struck down until FDR threatened to pack the courts, and it was eventually upheld by the Supreme Court. While I still believe that the government has no ability to interfere and disrupt the freedom of association between an employee and an employer, this is different. This is a mandatory arbitration. There is a method, a law, a judicial method in order to handle situations like sexual harassment, like discrimination claims, and to sort of subvert those expectations. It's really kind of gross, in my opinion. And as a result, it's unfortunate that the Ninth Circuit has upheld the injunction because I feel like there's a better method of tackling this. Uh, that's it for today. Thank you very much for joining. What do you think about today's video? Please comment down below, like, share, and subscribe. It really helps out. And I'll see you on the next one. Bye, guys.